Well, good morning, everybody, and welcome back to the ROS Media platform. My name's Andy, if you're here for the first time. If you're joining us on socials, great to have you with us as well. Let me first of all explain why we do these particular interviews together. I've got Ian with us. Ian is our president, our founder of the Republic of Old Souls, and also responsible for the protocols that we have here. These protocols are life-changing, guys, but it's important that you educate yourselves on how they can impact your life as well. And we've noticed over the past year to 18 months that there's been quite a knowledge gap, or certainly a gap in understanding in what people think is happening versus what the reality of the protocols deliver. So the goal is to educate you so that you can take decisive action and really change your life and your family's life for the better. Today, we're going to be talking about quite an interesting subject, but a bit of a mouthful as well. So we're going to be going into investment bank hypothecation. What is that? And we're talking about hypothecation of your signature credit. You may not even know what that is either. So what is it? Why do they do it? And how to redirect that signature credit back to you as well. That's the important part. Most people think that, a mortgage, a loan, credit card is simply, I borrowed money and I owe it back. That's typically how I used to think. That's probably how you may be thinking. I want to shatter that illusion. I want you to shift your focus from the loan to the title, because the banking system is using your signature as a permanent printing press to fund its own corporate activities by using something called hypothecation, which is what we're going to talk about today. The bank isn't hiding your name to protect your privacy. We're going to talk about how they do that as well. They're hiding it so they can profit off your signature credit value as just abandoned property because you didn't know any better. And I used this illustration the other day, and I'm going to use it again to try and explain hypothecation. Think of it this way. Imagine you had an expensive luxury vehicle and you parked it at a valet parking service and you went on a long holiday. Okay. Hypothecation is like doing that. And then while you're on your lovely holiday, the valet is renting it out to third parties for massive profit, pocketing the cash without your knowledge, all while charging you a parking fee. That is exactly what's going on with the investment banks. And here to explain it is Ian Clifford. Like I said, he is the founder of the Republic of Old Souls, responsible for all of the protocols that we have here, including our flagship, the Monopoly Game Changer. But today we're going to be talking about hypothecation. Ian, great to have you with us.
Well, it's an interesting subject and one that I should know all about years ago. But of course, they don't teach any of these things to the so-called professionals, of which I was one many years ago. So all of this has come about in my research since about 2016, when I was looking into how do the banks create loans? What's going on with that? And having read Professor Richard Werner's papers that he published in around that time, that was the door that opened for me to then look even deeper into what's really going on. And I'll be as bold as to say that I don't think anybody's gone quite as deep into it as I have with my research, because I've been looking around and I've never found research that goes into the depths that I have to uncover what's really happening. People have gone around the edges. A lot of people are aware of how banks create loans, what's called ex nihilo, but they don't go any further than that, including Richard Werner, which he goes as far as he wants to on his research papers and in his books and in his interviews, but he doesn't go further than that as to what's going on with the banks after this ex nihilo credit is being created. What are they doing with it? How do they use it? What's the framework really behind the scenes, which is what we're going to be talking about today. And if you're very new to this, it's completely completely turns banking on its head, which I think a lot more people should know about this.
It surely does. So let's dive in, because most people, if I go to a bank and I sign a mortgage paper, or I go to take out a loan, I'm assuming that that kind of stays with them, and that when I finish paying my mortgage and I've paid it all off, I then get the deeds to my property. But your reports and your papers mention a term called hypothecation and rehypothecation as well. In plain terms, how is the bank taking our signed paperwork and using it as almost like a pawn ticket to borrow money for themselves and then use that without our knowledge?
Well, it comes back to the reality that the system is artificial, that all the banks are in fact debtors in a worldwide bankrupt trust. And this is all came about after the bankruptcy, which is a permanent bankruptcy of the United States in 1933, in June the 5th, 1933, which we've spoken about quite a few times, House Joint Resolution 192, which pushed the United States as a corporate country into Chapter 11 bankruptcy and enabled the bloodline banking families, which provided a bailout of the United States, to become creditors in a worldwide, what became a worldwide bankruptcy. And the banks, the clearing banks and the investment banks, operate in this worldwide bankrupt trust as debtors themselves. But because the whole system is what's called usufruct, which is basically everything that is being seen as collateral, land, property, investment, assets, anything which the average person would regard as an asset, has been offered up as collateral to the original creditors, which is the original bloodline banking families, who offered out a bailout subject to taking legal title to the assets. And one of the assets that they've taken legal title to is the birth certificates, which is the artificial entity that's being created and registered following the registration of a decedent estate, which many people believe is them, but it isn't. It's the registration of the birth certificate entity, which effectively is the registration of the placenta, which dies. It becomes a decedent estate. It's registered to the state, and the state is a debtor to the original bloodline creditors. So you've got this artificial trust. I call it the Monopoly Board of Commerce. You've got all of these debtors that are playing the game of monopoly within this bankrupt trust. That includes the banks. So when banks hypothecate, what they're actually doing is they are taking advantage of a usufruct system where they, as debtors that are also operating as nominees, because they have a nominee status as well as being a debtor status, they can use the credit energy which the living souls put onto this Monopoly Board of Commerce, add to this worldwide bankrupt trust. The banks have got this unique position where they can use that credit energy, that signature energy. They can use it within a usufruct system as long as they pay taxes for the use of it. And that's the key. So they are not using the signature credit energy as creditors. They are using it as debtors and paying taxes for the use of it. And as part of that process, they can effectively multiply it. They can use it to multiply the effect and make more profit for the banks by multiplying it. It's the easiest way I can refer to it, is by multiplying its value and using a future value of something which was created from a signature, from the living soul signature, which goes on to the monopoly board at zero value. Of course, it has a high face value. Somewhere between the high face value and the zero value enables the banks to hypothecate, and they can actually take a multiplier of the face value. So, for example, a mortgage, which is created at zero creation value, because the signature is a zero value, the mortgage might be $1 million. The banks can use that $1 million future value and multiply it up by a factor, and use that multiplication to further profit from the credit energy which goes on to the board from the living soul. So it's like leverage. If you imagine a seesaw and you've got a fulcrum point, the banks can push down one end of it and the other end goes up in the air. That's leverage. They can leverage the use of the signature credit. They can multiply it. The legislation, the SEC legislation, the Uniform Commercial Code enables them to multiply the use of the credit that doesn't belong to them. They are effectively renting it from the original creators, which is the living souls. They get to use it, they get to multiply it, but they have to, and this is crucially important, they have to pay tax for the use of it, because they're not the owners of it. They didn't create it, they're using it. So like your analogy of the car, they're effectively renting it, making a profit off the back of renting it, but they still have to pay the original creditors taxes, unless the ultimate creditor, which is the creator, he who creates owns, turns up with the right structure to redirect the taxes on the use of the credit, which obviously the taxes belong to the creator of the credit, not the presumed creditors, which is what the banks are holding themselves out to be. Bit of a long answer, but that's basically it. So.
No, that makes sense to me, and hopefully it's making sense to you guys. And if you're hearing this for the first time and you're getting a little bit annoyed by that, then that's probably the right reaction to have, to be fair. It never belonged to the banks. They're using it to profit off of it. You are the originator. So let's talk a little bit about these secret owners then, because if the banks don't own the credit, but they're using it, they're paying taxes on it. There are, I mean, your document reveals, doesn't it, that the vast majority of mortgages and bonds and things like that, they seem to be legally owned by a mysterious partnership called Seed and Company that you talk about, acting for an organization called the DTCC. So I'd love to know what the DTCC is for the benefit of the members. And if this Seed and Company, if they hold the legal title to these assets, what does that make the rest of us? Are we just renters, or how does that work?
Well, in all property, you've got legal title, you've got equitable title, and which often is called beneficial title, because it's the who can benefit from it. Well, the original creator of the credit is the living soul, and they basically retain beneficial ownership over the signature credit. And what the banks do is they create the ex nihilo credit, they create these securities. Those securities are then sold on. So the clearing banks create the securities, which is from the signature of the living soul. That creates a debt. The debt is a negotiable instrument. It can be transferred and sold on to the investment banks. They purchase it, knowing that they can hypothecate it, knowing that they can use it for their own profit. What then happens is they've got to store it somewhere. So what they do is they bring in the depository trust company, or DTC or DTCC, and that company registers these securities, which then they bundle them up, they put them into tranches. They put them into these portfolios. They give them a reference number. There's a prospectus. They're registered through DTCC. The DTCC then takes legal title to them, to the tranche, not to the underlying securities, quite important, to the tranche. They take a legal title over the tranche, and they have the original creators, that's the living souls, as beneficial owners of the individual securities within the tranches. So it's a game of title ownership. So and then they create the investment banks employ Seed and Company, which is a subsidiary of the Depository Trust Company, to basically change the name, give it a name, give it a different name, this tranche, give it some other name. I refer to these as street names in my documents. So you have a name which is like a non-diplom. It's not a real name of the bank that ultimately is hypothecating. It's a made-up name which Seed and Company make up. But the giveaway is that in order to use the tranches of these securities and hypothecate, multiply the value of them, and use that to leverage it up and use it for trading and use it for collateral. What the originating investment banks do is that they pay tax, which is the giveaway. They pay tax using their EIN number, because each of the banks has its own employee identification number. So if you look at the investment bank's EIN number, that is hypothecating the street named tranches at Seed and Company, you can determine that the investment banks are using the tranches referenced by the CUSIP number, because that's an identification number for each tranche. So no longer can they disguise the fact that they're using these tranches, because you've got the CUSIP number and you've got the investment bank's EIN number. And then you've got the publicly disclosed tax payments, which the investment banks are paying for the use of the signature credit. So they get to use it, they get to hypothecate it. It doesn't belong to them. They try and disguise it through Seed and Company street names. Yeah. Their Achilles heel is the fact that they're paying taxes for the use of it. And that is the smoking gun, as I've called it in my research papers, the fact that they're paying tax for the use of it. Now, you wouldn't pay taxes on something that you own outright. You just wouldn't. You only pay tax because tax is like a rent. And you're paying tax to the bankruptcy trustee, which is the United States Treasury, because actually the birth certificates and the signature credit is collateral that they're holding, or they are collecting taxes on that signature credit, those birth certificates, the promises to pay, the negotiable instruments. The bankruptcy trustee is effectively collecting taxes from a debtor, which is the investment bank, for the use of that signature credit energy, which ultimately belongs back to the living soul. Bit of a long-winded answer, but that again is what's going on here.
Okay. So let's just dig a little bit deeper into that then, Ian, because you also mentioned in your paper that there's kind of three primary objectives here with what they're doing. You state that they are using this split title system for three corporate goals. The first one you talk about is administrative consolidation. So if we just cover that first, can you explain how sort of bundling all of these millions of our private signatures into these tranches makes it easy for Wall Street to trade our energy like a commodity? Let's start there, and then we could maybe go into capital expansion, and then I want to talk a little bit about this nominee withholding as well.
Well, tranches of investments is nothing new. Portfolios is nothing new. Rather than trying to trade individual promises to pay, individual negotiable instruments, they bundle them up, and that gives them they can actually get a rating. So they can go to rating agencies like Standard & Poor's or Fitch or Moody's and go, well, here we are, here's 1,000 mortgages in this tranche, and we want you, the rating agency, to give it a rating so that they can trade. It, and the rating is validation of its quality. And you can see this actually what's going on in the movie The Big Short, where they...
I was just going to say, is that where they kind of mix them up with, you've got A rating, you've got B ratings, and they even make a bit of a mishmash of all of them put together, don't they? There's a lot going on here.
Yeah, what they're saying is, look, there's 1,000 mortgages here. We've got some A-class payers here.
Yep.
We've got some people that were probably never going to default. Doctors, yep. Dentists, professionals who've got limited, there's low risk of them defaulting, all the way down to, the self-employed entrepreneur who's a hero one day and then bankrupt the next day, and goes through that boom and bust cycle that a lot of entrepreneurs go through, which not very good payers on mortgages. So you've got everything from the very, very reliable payers to the very speculative, high risk type payers.
Yeah.
And they tranche them together to water down the risk. So when they get a rating on these tranches, they can go out to investors who are effectively buying the income. That's what they're buying. They're not buying the tranche. They're buying the income. They want an income. So they will provide their capital to buy a proportionate percentage of a tranche to get the income, which is the interest, which the underlying mortgage borrowers, the alleged borrowers, which of course aren't borrowers really, they're creditors, or they are they're being represented by the creditors, which is the living souls. They want that cash flow. That is what that banks are buying and trading. But they can use the collateral value to expand their trading, to expand their capital through this leveraging effect of the value of the tranche, because the tranche has a high value because it's got a lot of interest that the banks are going to be collecting ultimately from the mortgagors, which is the alleged borrowers who are funding mortgages at the ground floor level, not at the top of the system, at the ground floor level, down in the local area with the local clearing bank that created the security through the ex nihilo signature and then quickly sold it on to the securitization market to an investment bank, who then put it in a tranche, who then disguised it with a tranche name, a street name, who then hypothecate it for profit, who then sell bits of it on, bundling it all together in these packages for risk mitigation. That's what it's about. Portfolios, and I was a portfolio manager. If you've got one asset, that's a high risk. Even though it might be a very, very valuable asset, it can disappear in value quite quickly if something happens. So what you do is you diversify and you buy lots of different assets and put them into portfolios. And that's what they're doing with these mortgage tranches. They're buying lots of different mortgages, mortgage securities, putting them in a bundle. That is meant to de-risk the bundle. It's supposed to lower risk. It's debatable whether it does or not. If there's an event like 2008 where very high percentages of people defaulted on their mortgages, because you've got all the same thing in the same bucket. You've got all mortgages in a tranche. So if there's a worldwide depression, that's going to be quite a high risk thing to have in your investment portfolio. But all the time people are paying mortgages, it's seen as low risk, and that's how to justify it.
Okay, so I want to talk a little bit about the capital expansion as well. Your paper talks about a strict 140% limit under SEC rule. I think it's 15C3 or 15C3-3. It speaks about that. So how did the investment banks use our hidden names to back their own corporate debts? And then how do they generate profits that exceed the face value of the original signature loan that we created, or the signature credit that we created?
Well, they can bundle our signature credit negotiable instruments into these tranches. That creates an entity in its own right. That entity they take legal title to. They can then say it's worth 1.4 times the component values of the individual securities. They can then basically use that as collateral to take lines of credit with other banks, believe it or not. So wow. They can go out to other banks who will provide lines of credit using the collateral of these tranches, which the investment bank has now got legal title to, but not the underlying securities. They've got legal title to the tranche, which is an entity in its own right. So it's quite a, investment bankers are pretty good at financial engineering, and that's what they're doing here. They're engineering. They're putting components together to make up structures which will enable them to enhance their profits, and they're disguising it, and they're using the SEC legislation because they don't generally blatantly break the rules. They follow the rules because they need to keep their licenses, and that's what they're doing. They're just using the rules the way that they're just playing the game of Monopoly based on the rules that favor them, and that's what they're doing.
Okay. And the third part, this tax capture, I want to talk about that as well. You speak about nominee withholding capture. It says that under IRS publication 1212 that the banks are legally supposed to report this extra income back to us using a form called a 1099 OID. So why are they intentionally not doing that? Why are they keeping completely silent so they can pocket the rest for themselves?
Well, if they were to file 1099 OID, that would make them basically they wouldn't be able to use that credit anymore because they would lose they are presuming that they're the holders in due course of the credit. But as soon as they file 1099 OID, they're making basically they're telling the bankruptcy trustee, which is the United States Treasury, that they are nominees, that they're not the creditors, that they don't have holder in due course standing, and that would collapse their game. They wouldn't be able to put these securities in tranches. They wouldn't be able to profit from them, hypothecate them, if they were to file 1099 OID, because that would completely change the game for them. So they don't do it. They're not compelled to do it.
Okay.
But if the true owner of the credit files 1099 OID through a nominee structure, now they've got no choice but to give up their presumption of creditor status, holder in due course status. They've got no choice because it's now on the record that the individual security, where a new structure, a new nominees turned up, filed 1099 OID, that changes the investment bank's presumption. They can no longer presume, which is, by the way, it's how a mortgage would be discharged at the top of the ledger by identifying the mortgage, the CUSIP number that it belongs to, the filing of 1099 OID from a nominee that takes over the holder in due course status, and the investment bank that claims that they are the creditor can no longer retain that claim, and that changes it. It discharges the mortgage, and the investment bank can no longer use that mortgage security as if it were theirs. They can't play the game of hypothecation anymore. No. They have to concede that they are just nominees. They are not creditors in any way on that particular mortgage. They can still carry on with the tranche because all these other mortgages probably don't have the true originating creditor turning up. So they carry on with their tranche, but they will lose the individual mortgage if that event happens.
Well, I can see why they don't say anything now. I think that, and I hope you guys can see that too. I mean, we're going to move into another section here as well called taking back control of title. So just think about what we've uncovered for a second. While you're working a 40, 50-hour week to pay off what you think is a debt, Wall Street's hidden your name behind an institutional street name. They've split the title and they're using your signature energy to back probably billions, if not more, in dollars of corporate expansion. They're thriving off your sweat equity and your silence, basically. The good news is you don't have to remain silent. You don't have to remain just a passive target for a bankrupt system. You can actually step into the role of what is known as a fiduciary creditor. You can be that person. So let's talk a little bit about that. Let's talk about taking back control. Once we've got to that point, or once somebody that's listening to this has got to the point where they've realized that Wall Street's tucked our signature away into their private little system, into their little game there, because you talk about this in the paper as well, how does setting up a 98 series grantor trust change the game? And when we've covered that, I'd like to also kind of dig into the Form 56 as well, Ian, because holder in due course, I mean, I know this, you know this, but many people won't. Holder in due course is such a pivotal part to this, isn't it? So I want to talk about Form 56 as well, but let's start with the trust side of things. How do we take back control of this?
Well, the banks are operating as nominees, but because the record has never been corrected. So as soon as a foreign grantor's trust is established, the grantor, which is the birth certificate entity that signed the mortgage or signed up under the contract for the mortgage, what they're doing is they're creating a separation between the birth certificate construct is a debtor entity registered to the state as collateral for the bankruptcy, this permanent reorganization, this HJR 192 bankruptcy. The birth certificate construct becomes a grantor of a international grantor's trust. But because the living soul is the beneficiary of that international grantor's trust or foreign grantor's trust, the foreign grantor's trust can file 1099 OID, and it can then become, the foreign grantor's trust under our IRS publication 1212 becomes the holder in due course, becomes the creditor, and is entitled to taxes that the debtors, and now the debtors, a debtor is the investment bank, is paying for the use of the credit. And so it's a tax redirection exercise, but it's also a holder in due course correction, because the banks are presuming that they're the holder in due course. No one's ever corrected the record. But now the foreign grantor's trust has corrected the record, and the foreign grantor's trust, through electronic filing, has filed 1099 OID and corrected the record, because as soon as the 1099 OID is filed and accepted by the IRS, now the foreign grantor's trust is the holder in due course, and that completely changes the game.
So I get the differential between debtor and creditor, and I want to talk a little bit about there's a trap there that many people have fallen foul of when filing 1099 OIDs as debtors, not as creditors. So there's the separation there from the actual debtor side of things, the birth certificate construct, the 98 grantor trust, separating that creditor status. But where does Form 56 come in with this then? Because that is an IRS document, isn't it? So you file something called Form 56 to declare you, or to declare the 98 grantor trust as holder in due course, so that you then essentially become the rightful boss of your own credit energy, as you should do. But how does Form 56 work? Why is that necessary? If the 98 grantor trust, when filing 1099 OID, becomes holder in due course, what exactly is Form 56 for?
Well, Form 56 is like a power of attorney. So what's happening is the foreign grantor's trust is filing a Form 56 with the bankruptcy trustee to say that they are the holder in due course. The grantor trust is the creditor and is taking over the taking over rights of the taxpayer, which is the investment bank, to move, if necessary, taxes onto the 945 tax module, which is the module which the taxes should be flowing from, because of the fact that the holder in due course is now the grantor trust, is entitled to tax redirection, but can't necessarily get tax redirection if the amount of taxes that the investment bank's paying are insufficient to meet the liabilities of the grantor trust, which might be more than one. It could be quite a high number of grantor trusts that have got a claim for tax redirection that can only be funded by the 945 tax module, but it may be underfunded. So the grantor trust uses a power of attorney because they have entitlement as the holder in due course to command the IRS to move taxes onto this payer's 945 tax module, which is where the tax redirection can only flow from.
Okay, so let's talk about that, because I know that this is an important part of the whole process as well. So we've gone from debtor to creditor status using a 98 grantor trust. We've got power of attorney and holder in due course through Form 56. You mentioned that the banks are supposed to keep a track of this tax withholding in a very specific account called Form 945, which you've just mentioned. But your paper also points out that because the banks never expect anybody to figure this out, they leave that account completely starved of cash, often funded less than 1% of what it should be. So why do they do that? And also, how does this sort of empty account, how can that act as a trap if people try to file a standard 1099 OID claim as a debtor, not as a creditor? So let's just kind of split that in two. Why do they underpay so massively on this 945 module?
Well, they know, at the very top of the investment banks, they know that the 945 tax module is for the original creditors, the entity, the living soul that creates the credit through the signature. But they also know that very few people in the world know this. So the original creditors never turn up and redirect the taxes. So, and also they don't want to publicize too much the 945 tax ledgers or modules, because if they put billions of taxes on there, somebody might realize or look into why they're doing that. So they underfund it. They disguise the name of the payer by using a street name, nom de plume, and then they underfund it because they know that very few creditors are actually going to redirect taxes from the 945 module. Right. So it's another way of disguising what's really going on, and they get away with it because they're not compelled by the IRS to fund the 945 tax module at the correct level, because there's never been anybody turned up to make a claim against it. Right. It's hard to anybody. I mean, there are some, of course, the elites are doing it, but that's not going to amount to a great deal across the whole market. So they basically are just playing the game, relying on people's ignorance who don't know how this system works. Yeah. But they don't have the control of the system. They don't have the power in the system, because as soon as they are no longer holder in due course, they lose all their power. Their power is deceptive. But once the truth is out, they lose that power of deception, because the truth is out. The grantor trust know the truth, the grantor trust have the holder in due course standing, they can make the tax redirection claim in line with the law, in line with the UCC and or any other legislation that supports the holder in due course.
So I get that. Anybody that potentially could figure this out if they went looking, and the 945 had, billions and billions of taxes paid onto it. I could understand why people would be maybe thinking, well, what exactly is this tax module? What are all these taxes being paid for? So to keep it under the radar, to make it look fairly insignificant in comparison to other tax modules, it is a safe harbor for them, or so they think. But let's talk about this executive command as well, because this is where the magic happens, isn't it? If the bank's sort of withholding account, the 945 account, is a pretty much an empty shell, shall we say, your papers say, well, we don't just give up at that point. The taxes are owed back to us. We can use an IRS rule, can't we, called Revenue Procedure 2002-26 to issue a manual command to the IRS. Can you explain how this actually forces the IRS to essentially march up to these corporate profit tax buckets, which one of them is called Form 1120, and then grab some of that surplus tax from there and drop it into this 945 withholding tax bucket that's pretty much empty, so that the IRS can then happily release our signature credit tax redirection? How does that work?
Well, it's all down to the standing of the grantor trust and the officer for the grantor trust making that command in line with the Revenue Procedure 2002-2026 as holder in due course. They have the power to command the bankruptcy trustee. See, the United States Treasury is a trustee in bankruptcy for the creditors. So a grantor trust, a foreign grantor trust, is a creditor. So the United States Treasury is working for the foreign grantor's trust because it's a creditor. So they've got to listen to it because that's their job. That's what they were appointed to do, is to collect taxes for the creditors. So a creditor is making a command to move taxes that it's entitled to onto the 945 tax module. So it's not asking, please, when you've got 5 minutes, can you do this? It's making a command because it's entitled to it.
Yeah.
The taxes belong to the grantor trust as holder in due course, and the legislation supports the command to be a lawful command. So the bankruptcy trustee can't really refuse to do it, and it doesn't make any difference to them anyway, because they've collected the taxes already. All they're doing is moving the taxes from modules which shouldn't have had the taxes paid on them in reality onto the tax module that should have been funded by the payer, but they didn't want to do that because they're trying to disguise the 945 tax modules.
I get that. So you've got huge surpluses on the 1120, not enough on the 945, but then the grantor trust comes in, has this powerful status of holder in due course, acting on behalf of the creditor as if they were the creditor, essentially, and saying, take it from there, put it on here, because there's not enough in this pot, and we are owed this back. Essentially, that's what you're saying, yeah?
Yeah, it's, when the creditor turns up, they've got all the power, and the foreign grantors trust has got all the power. It's got the standing to make commands, and the Form 56 is the power of attorney over the payer's tax module. So they've got absolute rights to do it as the holder in due course and as holding a power of attorney from the payer to rearrange the tax modules to what they should have already been in the first place.
Okay, so that Form 56 is very important, and holder in due course sounds like a very powerful position to be in. as creditor. So my question would be, do you want that power back? Because you may be feeling powerless in today's world. There's a lot, there's been some huge shifts, I think. People are starting to recognize that the shifts are taking place. The control agenda is creeping in. Work is getting harder, not easier. Inflation, cost of living crisis, all these different things that are making it harder and harder and harder for people to just get by. And if you now know that every debt you've ever had, going back as well, I know we haven't spoken about this on today's episode, but Ian has very, very methodically detailed out how you can go back to the age of 18 with this, that coming of age. So from 18 or maybe 21, if you're in the US, whatever that coming of age number is, but you can actually go back to the age of 18, the age of adulthood, as they call it, and reclaim all of these taxes that are owed back to you on your signature credit that you have created. So when I think about me, I'm 56 now, going on 57. That's a lot of years going back to age 18, an awful lot of years, 38 odd years that I have been pushing signature credit into the system and have never realized that as the creditor, I'm owed the taxes that the investment banks have been paying for the use of that. They've made millions off of me. They've no doubt made millions off of Ian and millions off of you. The taxes have already been paid. It's just a case of redirecting those taxes. So if you would like to learn more about how to do that, then we run webinars every single week on a Saturday morning, UK, 10 a.m. UK time. We run a flagship webinar. We're going to be running another one this Saturday where Ian's going to be diving even deeper into this very subject about how you can really turn the tables on the banks. So if you feel that it's time to do that, and I hope you do, because it was time to do that many, many years ago. It's just that nobody really knew how to do this. Ian's figured it out. Then we would encourage you to go here. If you go to roswebinars.is, you can register for our Saturday webinar. The only caveat to that is that we only have 1,000 seats on a webinar, and we always get over registered for those webinars. So if you want to join us on Saturday morning at 10 a.m., I would highly recommend that you register as quickly as you can. If you've got any questions, you can post questions at the registration point. You can even post questions on the webinar itself, and then I will pick up on those, and Ian and I cover all the questions that you have. So even if you come along and you don't fully understand all of the material, we're not expecting you to understand all of this and grasp all of this straight away. I didn't. It took me a long, long while, because it's a real big paradigm shift for people to make, isn't it, Ian? So I think if people can at least begin to open up their mind and get a bit more educated on this, if you've got questions, ask them, because then we can answer those questions on our weekly webinar Q&A. If you like more in-depth knowledge on how this all works, then you can go to ecclesialaw.is and you'll see all of Ian's technical papers on what we discuss on these interviews. So if you want to learn, where's the subject matter come from today's episode to do with hypothecation, there is a report, a detailed technical report on ecclesia law amongst probably 60 to 70 other technical reports on there that Ian breaks it all down. So head along there. And then if you want to see more of this going on, we do this 2 or 3 times a week as it is. But if you want to see past episodes of what we've been talking about together, you can go to our media platform, which is rosmediaplatform.is. And all the recordings are on there for you to watch as well. So I would love to see you on the Saturday morning webinar. I know Ian would love to have you there, where he can explain this in more detail to you. It's time to start acting as a creditor, not as a debtor. And when you know that you have the ability to do that, but do nothing about that, then that responsibility is on you, unfortunately. We can help you. As I say, you can lead a horse to water, but you can't make them drink. So we'd love to get you educated. We'd love for you to understand just how powerful a position you do hold as creditor. Time to stop paying that sweat equity to the banks. and to start reclaiming what is rightfully yours. And every Saturday, we show you exactly how to do that. So that's all I have to say, Ian. Any final thoughts before we let everybody go today?
Well, we're relaunching the Ian Clifford avatar, which we did a pilot, but then it was taken off air because the avatar platform decided that they didn't want people to know the information, so it was censored. But that's caused us to re-engineer it, and we've been able to do that, and it's nearly finished. So it's actually a lot better than the original. There's no bandwidth issue, because we had a bandwidth issue of simultaneously people trying to use it, and then there was a limitation.
Okay.
The video quality is, I think, is better, and the audio quality is better, and also the amount of information which we can load up to it is unlimited, whereas before there was a storage capacity limit. So actually the new avatar, which is due out anytime now, you can use that, you can ask questions, and hopefully that, together with the webinars and the Q&As and these interviews, you should be able to, and the research papers, of course, at Ecclesia Law, you should be able to figure this out and get started with your enrollment into the Monopoly Game Changer.
Yeah. And we have a team of consultants here that can help you do that, where we administer it for you. So it's just a case of getting yourselves educated, guys. We're not expecting you to do all the filing and do all of that side of things and know how to fill all these different IRS forms in. We have a filing team that is licensed and registered with the IRS that does all of that for you as well. It's just a matter of getting the education so you know exactly what you are doing and how significant this can be for you. So I hope you've enjoyed today's session. I certainly have. There's one thing that I learned today, which was that the power of attorney on Form 56 is also power of attorney over the 945 module. I didn't know that. I thought it was just power of attorney acting on behalf of the creditor. So that's something new that I've learned today as well. So thank you for that, Ian. And if you've enjoyed today's session, join us on the ROS Media platform. Like I've said, there's plenty more there you can dig into. And we hope to see you on the webinar on Saturday, 10 a.m. sharp. Have a great day.